Thank you. We're going to get started here. If you could take seats. So I'm Baron Tech Freedom. Wanted to thank all of you for coming today. I'm going to introduce our host, and then Chris is going to introduce Commissioner Ohlhausen. But just briefly, I'll give you my normal thank you for coming. Update on what we at Tech Freedom have been doing. We've been busy on privacy and a number of FTC issues as well as telecom issues. So encourage you to check those out as well as our new website at techfreedom.org. Before we get started today, please make sure that you mute your phones, and please do join us on the hashtag, which is FTC100. We'll take questions from that today during our fireside chat with Commissioner Ohlhausen. And we'll have Commissioner Ohlhausen speak for about 2 minutes, and then we'll join her in a fireside chat, pressing more. Is the audio cutting out, or is that just me? It is cutting out? Okay, we're going to wait a few minutes to get started. Or do you want to try using that microphone, Will?
We're going to have to circulate that around.
Okay, well, let's test this out. So how does that sound? Is it on? So that works? Okay, great. Well, in that case, I will turn things over to Chris and just briefly introduce Chris to all of you. So Chris is a partner here at Holland & Knight, someone whose work we've discovered. He's written extensively on the Holland & Knight privacy blog about the FTC's recent decisions. Before joining Holland & Knight as a partner, he was in-house at ChoicePoint, which, as many of you know, had some FTC issues over the years. So he's been working on privacy for a long time. I couldn't have asked for anybody better to introduce Commissioner Ohlhausen or to join us today for our chat. So, Chris, please.
So is this working? Can you hear me?
We'll replace that one. There we go. All right, how's that? Better? Okay. So, hi everyone. I have the honor of introducing Commissioner Ohlhausen. Just briefly about the Commissioner's background. Commissioner Ohlhausen was sworn in as Commissioner of the FTC on April 4th, 2012, and she is in a term that expires September 2018. Prior to joining the Commission, Commissioner Ohlhausen was a partner at Wilkinson Barker Knauer, where she focused on FTC issues including privacy, data protection, and cybersecurity. Commissioner Ohlhausen previously served at the Commission for 11 years, most recently as Director of the Office of Policy Planning from 2004 to 2008, where she led the FTC's Internet Access Task Force. She was also Deputy Director of that office. From 1998 to 2001, Commissioner Ohlhausen was an attorney advisor to former FTC Commissioner Swindle, advising him on competition and consumer protection matters. She started at the FTC General Counsel's office in 1997. And before that, Commissioner Ohlhausen spent 5 years at the U.S. Court of Appeals for the D.C. Circuit, where she was a law clerk for Judge Sentel as staff attorney. Commissioner Ohlhausen also clerked for Judge Yock of the U.S. Court of Federal Claims from 91 to 92. And by way of education, George Mason, and graduated from honors from University of Virginia. So the important part, she lives in Virginia, married to Peter Ohlhausen, and has 4 children. Don't know what ages, but maybe you'll share that with us. So we're really honored to have Commissioner Ohlhausen here, so let's give her a warm welcome.
Thanks, Chris. Thanks so much for having me. Hearing that kind of long list of things and then asking what age my children are, hi Bill. The name of this talk is 100 is the new 30, right? Keeping the FTC vital in the digital age. But hearing that long list makes it sound like I was there for almost 100 years at the FTC. Sometimes it only feels that way, but I've been delighted to spend so much of my career there. So I'm here to talk a little bit about the FTC at 100 report. This was in anticipation of the FTC's 100th anniversary. Yesterday was our 99th birthday, so we are starting in our 100th year starting today. So in 2008, then Chairman Bill Kovacic asked me to oversee an agency self-assessment in anticipation of our 100th anniversary in 2014, with the idea that we should assess what we're doing, kind of a top-to-bottom review, and think about how we move forward in the next 100 years. So the report of that self-assessment, which was called it has a long title, the FTC at 100 into our second century, the continuing pursuit of better practices, was released in early 2009. And it really represented an agency effort to create a framework for assessing our performance and to identify where and how the agency could improve as it moves into its second century. So it wasn't looking at, oh, we got this case right or that case right, but more looking at our structure, our process, our resources, how we kind of do things in that regard to see what was working and what could be improved. So it asked two fundamental questions. First, how well is the agency fulfilling the role that Congress foresaw for it when it created the agency in 1914? And then what kind of agency should we aspire to be as we enter our second century? So to answer these questions, I and several of my FTC colleagues undertook a 7-month review that solicited the views of practitioners and scholars in the U.S. and around the world. We talked to former government officials, current officials, experts about governance, antitrust experts, consumer protection experts. We had workshops in the U.S., we had international workshops. And the result was a comprehensive 200-page report that combined these views along with scholarly research on agency functioning to craft a set of recommendations for our agency. So what did this report recommend? What did we, distill this all down to? So here's what we addressed. Here's what we thought we should look at. What resources the FTC will need in the future, how the agency can better select its priorities for exercising its powers, how to strengthen the agency's processes for implementing its programs, and how to improve links with other government bodies and non-government organizations. So although all of these recommendations are important, I wanted to highlight a few that have thus far had the greatest relevance in my tenure as an FTC commissioner. So one of the great things when I got nominated to be a commissioner and then once I started was to have this foundation of having worked on this project and worked at the FTC for so long, to have an idea of how the agency should be functioning, how we should use our powers, how we should talk about what we do. So here are a few of the areas that I thought were most relevant thus far to me. So the report said that a fundamental requirement is that the FTC clearly articulate its mission. And I think that's really vital and continues to be a vital part of what we do at the agency. So I think one of the reasons I got tapped to do the FTC self-assessment was I actually oversaw the drafting of the agency's strategic plan, the plan that ran from 2006 to 2011. And that was really a fundamental part of it. How do we measure success, and what is success? What are we trying to achieve? So what is our mission? So the FTC's mission, in its most basic terms, is to prevent business practices that are anti-competitive, deceptive, or unfair to consumers. I think that's pretty basic. To enhance informed consumer choice and public understanding of the competitive process, and to accomplish these goals without unduly burdening legitimate business activity. And so this obligation goes well beyond just creating a mission statement that we put in a document and put away in a drawer. And I think it requires the agency to clearly articulate not just what it is doing when it takes enforcement actions or issue guidance, but also explain why these activities will further the agency's mission. So another key part of the report is that the Commission use all of its tools to further its mission and to evaluate carefully what tool is appropriate for any perceived problem. So we're primarily a law enforcement agency, but the FTC also has all these other tools, and I really got experience with that when I headed up the Office of Policy Planning, because my role there was to figure out, are there problems that we should be addressing? Are there areas where we can't necessarily bring an enforcement action, but how can we still make things better for consumers? And so that might involve research, that might involve advocacy to other decision makers, it might involve guidance, or sometimes it might involve saying, well, really, the market's going to take care of this, so we really shouldn't do anything in this space. So we really always need to think very carefully about what tool we use. And then finally, the report recommends, or not finally, penultimately, the report recommends that the Commission pay close attention to its outcomes, and not outputs and not inputs. So not merely saying we're successful if we bring a lot of cases. That doesn't necessarily say whether those cases are well targeted, those cases are appropriate, are they making consumers better off. It's a simple measure, but it's necessary to keep track of that, but that itself is not sufficient. So we have to actually think about what we're doing. Is it really making consumers better off? And can we do it more effectively? So we really need to focus on outcomes for the public, for example, preserving competitive markets or preventing fraud, rather than saying, we brought 20 cases or we have a budget of this amount. So then finally, the FTC at 100 report recommended that the agency continue to build and support, build and maintain support for the FTC's mission. And that is a very broad obligation. So we have to do it throughout the government, throughout the administration, with Congress, with the states, with industry, and the public at large. So we need to do this through outreach to other institutions and groups, and also by, providing a careful explanation of what we're doing. And it's also important that we do this through international engagement, both with other countries, specific countries, as well as international organizations, because we're in a very global, interconnected economy these days, and so our consumers will be better off if the world also adheres to some of these competition and consumer protection values. So taking these principles from the report, how have I put them into action as a commissioner? So, there's countless instances in which I've supported FTC action that I think was consistent with these recommendations. One notable example is when the Commission closed the Google search case because the evidence suggested that the conduct at issue on balance benefited consumers, despite the complaints of some competitors who argued that they had been disadvantaged by the way Google ordered its search. However, because things are typically seen better in contrast, right? So if we just talk about all areas of agreement, it doesn't necessarily make things very clear. I wanted to discuss a few high-profile matters in which I didn't support the Commission's actions because I believe they were not consistent with the fundamental principles from the FTC at 100 report. So one of my main values that I've tried to pursue as a commissioner is transparency and predictability. This is something that recurs throughout the report, having a mission, explaining why what we're doing is furthering that mission, doing outreach. So it's really vital that the Commission explain what it is doing and why, and also equally explain what it's not doing. So transparency about how we enforce the law is vitally important to the Commission. It's also important to the particular parties before us. But it is also important to business in general, so they know how to order their activities. It's important for us to gain support and understanding in other parts of the government, for them to really understand how we are making decisions and why we're making them. So having a clear mission is really an important part of this. It helps guide our staff's activities, it provides guidance to market participants, and it helps build support for our mission. So one of the first things that I did, my first dissent as a commissioner, was on the basis of basically predictability and transparency. So in July of 2012, the Commission decided to withdraw its long-standing policy statement on using disgorgement in competition cases. So this was a bipartisan statement. It had been endorsed by the Antitrust Modernization Commission, numerous other antitrust officials. And I was concerned when the Commission withdrew this statement and didn't replace it with any other guidance. It simply said, the case law will be enough. And I was very concerned that we were moving from having clear guidance on disgorgement to virtually no guidance at all on this important policy issue. So that was one of the areas where I felt we were not pursuing the goals set out in the FTC at 100 report. Also, some of the standard essential patent cases were another area for me. This was the Bosch case and the Google MMI case. And I was concerned about predictability and transparency in these cases for several reasons, but one in particular is involving the use of Section 5 as an unfair method of competition. So that's an area where the Commission, it has this authority under the statute to address unfair methods of competition, but it's never really explained what that means. And in comparison, we have an unfairness statement on the consumer protection side. We have a deception statement on the consumer protection side, where we've really given guidance, given an understanding of how the FTC interprets those broad terms and how it will apply it as it brings enforcement actions. The FTC has never done anything in that regard in the unfair methods of competition. And just to explain, we have under Section 5 the same authority under the Sherman Act, right, that the Department of Justice has. So what I'm talking about is not where Section 5 is coextensive with the Sherman Act, but there are some people who believe that Section 5 gives the FTC additional authority under unfair methods of competition beyond what the Sherman Act can reach. And that's where my concerns lie. So I was very concerned that we were enforcing this part of the FTC statute without really giving clear guidance to businesses, to other parts of the government about what this meant. So I was also concerned that we were creating some conflicts by having two different standards for patent holders, because this applied to people who held patents, depending on whether their behavior was being reviewed by the Department of Justice, which can only enforce the traditional antitrust laws, or by the FTC. So we were kind of creating this conflict that I was concerned about. And I think that could cause confusion in the market and undermine predictability for market participants. So those were some examples of where, thus far in my tenure, I've used the teaching from the FTC at 100 report to guide my decisions as a commissioner. So turning to the next 100 years, so what are some of the recommendations for looking ahead? So I think we should really carefully evaluate everything we do. And that's from, administrative litigation power to our internal resource allocation, obviously our Section 5 authority, and to, including how we measure success. So our centennial really provides a perfect opportunity for a systematic agency-wide assessment to look at, what are we doing doing it right, and can we improve? So, thinking about that, the report, the FTC at 100 report came out in 2009, so I've had a few years to think about it, and I wanted to suggest some additional areas for improvement looking ahead. So one of the main things is I think we need to really more clearly tie enforcement goals to our mission. So in our consumer protection area, I think this means continuing to prioritize fraudulent conduct. It costs consumers real money, especially in tough economic times. People really understand why we're doing that. And it's also important for legitimate business because it's hard for them to compete against fraudulent actors in the marketplace. It raises their cost of doing business as well. In the antitrust area, I think this means focusing on anti-competitive conduct and transactions that cause significant consumer harm. So that's what we really should be focusing on. Is not, do we think this behavior isn't nice? Do we think it's, people should play fair? We really need to focus on, is this harming consumers? And I think this focus is also important as we prioritize our resources, but it's also important as a way to focus on what we're doing to avoid unduly burdening legitimate business, particularly in high-tech and rapidly innovating industries. And when we focus our scarce agency resources on speculative harms or just harm to individual competitors that don't really flow through to consumers, we may ultimately end up making consumers and competition worse off. One of the other recommendations looking ahead is to use the right tool for the task. So, as I said, we're primarily a law enforcement agency, but we really should consider all our non-enforcement tools as well. Sometimes that can help stop consumer harm before it arises, which spares consumers losses and spares businesses as well. If they know what our requirements are and they can adhere to them, really everybody's better off that way. And so what are some of these tools? We've got our policy research and development tools. We've got competition advocacy. And competition advocacy is where the Commission uses its expertise in antitrust and consumer protection and economics to give advice to other policymakers as they're setting regulations or making rules and laws for consumers. So that has been a very cost-effective way for the FTC to focus on making consumers better off in an area where it can't bring an enforcement action directly. Another area is letting self-regulation work or encouraging industry best practices. And sometimes that's really the best tool to deploy, particularly in areas where we might not, because of the First Amendment or because of rapidly evolving technology, we may not have the ability or the expertise to really get in and set specific rules for industry. And sometimes it's for the FTC to add some insight and some knowledge into the debate, but it's maybe not necessarily the right actor. Another part of the government really might be the policymaker, the enforcer that has the expertise and should pursue action in that area. And sometimes the market is really, or often, I would hope most times, the market is really the best tool. So again, our yardstick should be whether we're making consumers better off, not necessarily whether we're bringing a lot of cases. Another recommendation is to stay focused on our core competency. So despite the recurring interest in Section 5 of the FTC Act, or unfair methods of competition power, I think our core competency has really been in the antitrust law area. We've had some real successes as an agency in making improvements to the antitrust law in this area. We had some real successes involving the state action doctrine. We had a unanimous Supreme Court victory in the Phoebe Putney case. We've brought a number of hospital merger cases where we've been able to stop anti-competitive transactions. And so I think that's really where the FTC should focus its efforts, is on improving the implementation of the antitrust laws. I think that's where we've really brought a lot of value to consumers, a lot of value to antitrust thinking, and I would definitely encourage the agency to continue to bring all of its tools to bear in that area. And then finally, clarifying this, or not finally, but another issue is clarifying the scope of the agency's unfair methods of competition authority before invoking it. So my view is that because our core competency is really in antitrust law, I suggest that that's where the agency should focus. I don't actually think we should engage in a lot of work in the unfair methods of competition area, because we should really be focusing on antitrust law. But should the Commission want to move forward and bring more actions using unfair methods, I think it's incumbent on us first to explain what are the parameters of that authority, what it reaches, what it doesn't reach. And so I've laid out a number of factors that I think should guide the FTC if it were to come up with an unfair methods of competition statement. So you probably won't be surprised to hear them, because they're drawn very much from the FTC at 100 approach. So we should focus on substantial harm to competition, not to competitors. We should look to whether the behavior at issue lacks a pro-competitive justification, or if it imposes a disproportionate harm on competition. We should also avoid or minimize institutional conflict. I talked about this already. If the Department of Justice is enforcing just the antitrust laws and we're enforcing something in addition to that, that can make our dual enforcement authority, oversight authority with the Department of Justice, actually have a liability implication. So if your conduct gets reviewed by the FTC, something might be a violation, whereas if only the DOJ is looking at it, it's not. And I think that causes some real problems with predictability. We need to ground our unfair methods of competition enforcement in robust economic evidence. That's important to all the work we do. We should look at using other tools as alternatives to our unfair methods enforcement. And finally, we should provide clear guidance. So I think you can see why my factors for any UMC statement draw heavily upon the FTC at 100 approach. Then finally, I'm not against, expanding authority in all cases, the FTC's authority. I think that one of the things we've seen over the past 100 years is really a big change in how communications take place. Previously separate areas of communications technology have really all converged so that consumers are receiving information and communicating with each other in ways that previously were very separate. And so I think having the common carrier exemption, which walls the FTC off in the consumer protection area from certain entities, doesn't really make a whole lot of sense anymore. So I would recommend that Congress seriously consider removing this limitation on our jurisdiction and putting these competing, because now these platforms all compete with each other, and putting them on equal footing. And this is something that the Commission has supported in a bipartisan way. Then we also need to maintain our technological capabilities, and that's something I think the fireside chat portion will talk about a lot. The FTC at 100 report stressed having the right personnel, capital, and information resources. And so obviously the FTC does a lot in the technology area on both the consumer protection and the antitrust side. And so we've undertaken some efforts to make sure that our understanding and our expertise keeps up. So starting in 2010, we now have a chief technologist on our staff at the FTC, and he or she advises the Commission on evolving technology and policy issues. Our first chief technologist was Ed Felton from Princeton, and now we have Steve Bellevin from Columbia University. We've also developed a mobile technology unit in our Bureau of Consumer Protection, and that follows and issues and does research and brings enforcement actions, looking at apps, mobile. I mean, it's so important. Consumers now are really accessing the internet so much more through smartphones, through their handsets, and we need to keep up with that because we need to understand how what experience consumers are having. And so that's an important tool. And we've done a lot of workshops, a lot of research in this area. And then finally, I mentioned the workshops. It's a very important tool that we bring. We're having a workshop on the Internet of Things in November. We've done a lot in the mobile space. And I think that's one of the most important tools that the FTC can bring to bear because it not only educates the Commission, it also gives sort of a space for industry, for researchers, for other parts of the government to come in and talk to each other and get a better idea of what the FTC's concerns are in this area, which again help promote predictability and transparency. So with that, I'll stop, and I'm happy to take questions during the fireside chat portion, and thank you so much for listening.
So as we situate ourselves over here, let me just remind you that today's event is co-sponsored by the International Center for Law and Economics and co-hosted here by Holland and Knight. My colleague Jeff Manny is going to be joining me from ICLE, and also I will remind you that the Wi-Fi is open. If you log into HK Guest, I believe, the password is yellow30. So please tweet your questions on the FTC 100 hashtag, and we'll be sure to work them in.
We should have called it coffee table chat. We don't really have a fireplace. One thing I want to say before we get started is I don't know how many of you have read the report, the FTC at 100 report.
It's very short. It's only 180 pages?
No, it's like 2 something, isn't it?
By the time you have all the appendices, it's about 200 pages.
Yeah. I was going to say it's quite good, though. So it is actually really worth reading. It's a great history. And I think the thing I liked most about it was that it wasn't, we are perfect. It was, here are recommendations for moving forward. It's really worth a read. So if you have some time during the weekend to spare, you should read it.
Well, I'm a big believer in regulatory humility, and I've mentioned that in some of my statements, and I think it is important for us to take a hard look at ourselves.
Well, Maureen, that's probably a good place to start. So is that just your own belief, or do you actually see that in the history of the agency, in its statutes, and in the things that it said in the unfairness and deception policy statements, that idea of humility?
Well, the unfairness and deception policy statements, there's two elements of those that I think are important. One, in the deception statement, is we do talk about what's material to a reasonable consumer. So that, I think, was sort of a reordering of the FTC's thoughts so it had been using its deception authority and its unfairness authority in ways that became controversial, and it lost political support for what it was doing. So it undertook a process of developing these statements, the deception statement and also the unfairness statement, to really put some limits on itself for the way it would use this authority. So that, not that the FTC knew everything, but it was trying to look at things from like a reasonable consumer. And so often, for example, in cases, say in the area of advertising, we'll rely on, was there consumer testing? What did consumers take away from this ad? I think that's always important to look at. Now, in unfairness, there's a balancing test. We have an unfairness statement, but there was also a change to our statute. And so it looks at this practice, does it cause substantial harm? Is that harm, is that outweighed by benefits to competition? And was this something that consumers could reasonably avoid? So again, I think that creates a little bit of testing, right, of, are we right? Are we making the right decision? Are we striking the balance in the right place?
Right. Well, maybe let's step back and just talk about the report and how you see the agency's prospects. You looked at them back in 2008, 2009. What do you think today as you look forward?
So I think the FTC is, we're a fairly small agency, right? We only have about 1,200 employees. We have a very broad authority.
But there are those that love it.
I love it. I devoted a lot of my career to it. But I think we've been able to do, punch. Bill Kovacic would say we punch above our weight. Mm. And I think one of the reasons we're able to do that is by using some of our unique capabilities that we have. So we've got our policy tools. One of the things when I headed up policy planning that we would do is try to look a little bit over the horizon and try to anticipate what was coming down the road. So I think that helped make us a little bit more effective, and also to bring to bear our various policy tools. And so one of the other things that we did is to try to say, where can we improve areas of the law? So to talk about the state action doctrine, this has been a long-term investment at the FTC to make that state of the antitrust law better. So we had a
Do you want to explain?
Sure. So the state action doctrine is basically saying that if a state takes an action that's anti-competitive, that's not subject to the antitrust laws. So the question is this really the state taking that action, or has it just delegated this authority to private actors? So it has to be clearly articulated, and then if it is delegated to a private actor, actively supervised. Because the idea of the state action doctrine is it's not supposed to obscure political responsibility for anti-competitive regimes, it's supposed to assign political responsibility. So that area of the law had gotten kind of fuzzy, and states were kind of protecting from competition areas of private activity that we thought was bad for consumers. So there was a long-term investment at the FTC across many administrations in trying to improve this area of the law. So there was a state action task force under Chairman Muris that I worked on. Then we worked to develop cases that could bring this issue to the fore. We finally, so we did a report. So we had a task force, we did a report, we tried to generate cases, and then finally we got one to the Supreme Court where we won. It's not too often you get a 9-0 verdict out of the Supreme Court. And so so that, I think, is one of the areas why we've been able to be so effective is because we do sort of take this global approach of studies, reports, cases, advocacy, outreach that all kind of come together.
Well, but before we move on, let me just ask you about what might be the most popular thing the FTC's done since the Do Not Call registry, which is defending Uber. There are a lot of people out there who are very worried that the DC, the Portland, the San Francisco Taxi Cab Commission are going to kill Uber. And they were very heartened, those of them that saw it, to see the FTC jumping in to defend Uber. That's exactly the kind of thing we've said, that if the Federal Trade Commission is effectively going to become a Federal Technology Commission, which is more or less what we see it becoming, that's a great example of the FTC defending a new technology from state action to the extent that it can. Do you want to say anything about that?
Uber was a great example of a new disruptive technology that, kind of engenders a response from the entrenched interests who are trying to use protection of state or DC or local regulation to maintain their business model against a new competitor. And that's something we've done over and over again. Uber is a popular example. We did this in the online direct shipment of wine. Right, that's a big area where we've invested. I've tried to focus a lot of attention on new deliveries of healthcare delivery models. So sometimes it's not a technological advancement, but it might be a new way to deliver care. So, for example, having the nurse practitioner in Target or in CVS or something like that. So we've done advocacies in that area. And actually, looking forward this year, healthcare technology, new methods of delivery, so remote care, remote telemetry, new devices are an area that I'm going to personally focus on.
So let me keep along this line. You mentioned just a little bit earlier about how to improve the unfair methods of competition approach, and I might distill a lot of what you said by saying, and correct me if this is putting words in your mouth, we need more economics in our approach to consumer protection issues, or to issues generally under the consumer protection statute, like we have in antitrust. I, of course, think that would be great, and there are many who share that view. I wonder if you could talk just a little bit about how we get there.
Right. So, using economics in the consumer protection area is very important. One area where we've actually had a lot of, we've relied on it a lot is actually in the advertising area. Yeah. So, for example, one of the things I was involved in previously is the advertising of prescription drugs to consumers. And there's this feeling that that's bad and that shouldn't be allowed. And there's actually good and also health claims on foods to consumers. And the FTC, Bureau of Economic Staff, has done some wonderful research in this area that really explained how that advertising really helps educate consumers. And so Pauline Ippolito from the Bureau of Economics did a wonderful study on fiber, right? Fiber in the diet. And what she was able to show was that once that advertising claim, so the government had been, advocating this, and it wasn't really getting through to consumers. Well, once companies started advertising that for their cereals, consumers changed their diets. And one of the most interesting parts of this is the consumers who were least likely to pay attention to government notices on this, it had the biggest impact on their diets. Reading the back of that cereal box, watching that ad on TV. So that was a wonderful example of using economics in a consumer protection area to show that this really made consumers better off. Right. And so in the prescription drug area, we showed that consumers actually, they gathered information about whatever healthcare condition they saw advertised, and they went in and they talked to their doctor. Well, that's a pretty good outcome. So it's not and the doctors reported that they didn't feel pressure to prescribe that particular drug, but that it actually brought people in to find out and get more care about themselves. So it was a really good use of economics. Sure. I personally would like to see a little more of that brought to bear in the privacy area.
So how would that work? How would you bring that to bear more in the privacy area?
You mean procedurally, or is it like?
Yeah. So you have a Bureau of Economics.
Yes.
What would you imagine that it might do that it isn't doing enough of today?
So one of the things that I think would be useful, and I'm not trying to say they're not doing this today, but when we're looking at unfairness, okay, which has this balancing test in it, part of what we're saying is, okay, what's the harm to consumers? So that could be, sometimes measured through economics. What's the benefit to competition, right? And the balancing between those two. So I think that's something that economics could shed some light on.
Can I ask? I want to ask a question or follow up on that point about economics and unfairness. So you mentioned the unfairness test.
Yes.
Substantial injury that's
right.
not outweighed by benefits. There have been consent decrees recently, or investigations resulting in consent decrees, that some would argue that that test has become a little bit more squishy, and that traditional harms, economic, financial harms, or medical-related harms, those sort of tangible harms, that is expanding beyond that. Do you have thoughts on that? I mean, you've already touched on it a little.
Sure, I do have thoughts on that. And when you go back to the unfairness statement, it does identify what could be substantial harm as medical, financial, health and safety, and children. And also quiet enjoyment of the home, which is actually what the do not call rule is based on. So I always try to look at, when I review a settlement, to make sure it falls within the parameters of our authority. So for example, we have some cases where, so going to like the designer wear case, for example, where you had the rent-to-own store that was taking screenshots and accessing and turning on the camera of people's rented laptops in their homes. Right. Some of the data that they were collecting was medical information, was financial, your banking website, but also things that showed, these children are home alone, every day from 3 to 6. And if somebody, got that information, that could raise, a safety risk to children. So I try to keep it cabin. I don't think that just sort of this, just generally makes me uncomfortable kind of, that's not enough for unfairness, but if you can tie it to a more concrete risk.
And that's you what I think is so interesting and great about you as a commissioner was your background as representing companies before the commission prior to that. So I think your perspective you bring is great in that way. I think one of the things that now that I'm on this side representing companies before the FTC, and I think one of the things that companies struggle with is as that test expands or changes or becomes broader than just the tangible harms that you described and mentioned, it becomes harder for companies to design products in anticipation of what the FTC might find to be an unfair practice, whether it's a default setting or a sharing that happens. So it becomes harder for companies, I think, in my view, to prepare themselves or ensure that they're designing products fairly. And so I think I don't know that I'm even asking a question other than to say it seems like you fall on the side of making sure, or when you're deciding how to vote, that a tangible harm or an actual harm
substantial harm
okay. Has been met.
Right. No, I always do go back to that and try to look at that, because I do think, as I said, predictability, transparency, those are all important values.
Can I turn that into this question? It's sort of interesting hearing you talk. I was immediately thinking about this sort of debate about whether the FTC has built a common law around some of these areas, and we don't have to talk about what that means. I mean, we all have an idea of what the common law is, but I suppose if it means anything, it does mean a kind of evolution of the understanding of what terms like unfairness or substantial injury mean in the face of changing technology and changing practices and everything else. In other words, it must be sort of like the Constitution. It's contemplated that there is something that remains constant, the language of the statute, and something that evolves as the environment evolves. I wonder if maybe you could talk about that, about how you see whether the FTC has developed this common law, whether that is what they're supposed to be doing at all, and your thoughts about how well that accomplishes this objective that Chris was outlining.
So, one of the benefits of enforcing both antitrust and consumer protection is I can sort of see how things are done on both sides. Yeah, right. So when you think of the Sherman Act, right, that's a pretty general statute, and it has been articulated and interpreted through the common law, through courts applying it, through guidance through the FTC. Right. On the consumer protection side, I think we've done something similar. We have this authority, unfair and deceptive acts or practices, and we have cabined it based on these statements. We've tried to give guidance for specific things, like for debt collection or advertising to children, whatever, what have you, a little more specific guidance on what we mean by that. But as technology changes, so I think back to so I was at the FTC when we brought our first real online case, the GeoCities case, right? So that was a deception case where they said, we're going to do X with your information, and they did Y. But, technology has changed so much. I think it would be very difficult and really unworkable to have defined at that time, exactly. The technology is always, a year ahead or more from what we're doing in the enforcement area by the time or even the policy area. We try to stay a little bit ahead. We try to look over the horizon, but, it's hard to do. So I do think that having some flexibility with some clear parameters about what do we think unfairness is, what do we think deception is, and the need for us to articulate that clearly. Like, I'm always pushing to have a clear statement. What are we doing? Why are we doing that?
So do you think overall, not any particular case, but overall that the Commission has articulated clearly enough the process by which it understands unfairness to change over time?
Well, I mean, I'm not so sure that unfairness changes over time. The facts change over time, right? The facts to which we're applying unfairness change over time. So, having, a rent-to-own computer with software that turns on the camera in your house, well, we weren't anticipating that in the 90s, right, in the GeoCities case. But it's still, that harm of, medical information, financial information, health and safety risks. So when you go to the International Harvester case, like, for example, that was a health and safety risk, and that was unfairness, right? So that was applying it to different facts and not particularly technologically advanced, sure. But it was the same. It was the same idea.
And we should probably mention, for those that don't know all their FTC cases by heart, that's the case to which the
fuel
unfairness...
geysering. It was tractors that if you open the fuel cap while it was hot, it caused gas.
So that was the cutting-edge
to
technology of 1980.
That's right. Right. Yes.
And that was the case to which the Commission attached the unfairness policy statement.
That's right.
And what you described earlier is almost verbatim a description from that statement of how the Commission said that, of course, it would be too difficult to list all the practices that would be unfair at any particular point, and there has to be an evolutionary understanding. But you also mentioned antitrust law, and there does seem to be a pretty significant difference in the two bodies of law. And it seems that antitrust law goes before the courts regularly. So even though the facts change, the courts have weighed in repeatedly over the years and explained what they think the Sherman Act means, what those very short statutory terms actually mean in practice. On the FTC Act side, both on unfair methods of competition and on unfair and deceptive acts and practices, there really hasn't been much litigation. And you described the lack of certainty right now about unfair methods of competition. It's been, since 1972 that we've actually had any sort of court decision on what that means?
No, I think Abbott Labs was in the 90s. But...
Okay, so we've had a little bit, but it is very different from antitrust law. So how do you compare and contrast those two bodies of law? And do you think that the FTC could, in applying both the competition and the consumer protection sides of its own authority, do you think it could do something more like antitrust law works, or if it's not going to have that kind of litigation, how do you think it fills that gap?
Well, I mean, we do have a litigation. We have administrative litigation. We've just recently had the Palm case, which is now on appeal to the D.C. Circuit. That was an application of our deception authority. We just heard oral argument on the McWane case, which is an antitrust case. And we do, litigate in court, but we do have a lot of settlements, and it is true. Now they have settlements at DOJ too, so I'm not sure how different we are. I mean, if we have a party who's willing to settle with us, I can't see that it's a really good use of resources to say, no, we're going to force you to litigate.
Sure. But given that happens, and it tends to happen a lot, especially in technology cases, are there other things the Commission can do, as you were saying, to provide guidance? For example, what do you think is the goal of workshops and reports?
Oh, well, I think those are very good ways to provide guidance. So we do give, for example, we recently revised our .com disclosures on how we think, disclosures should be made to make things not deceptive. As consumers are now looking at things on their handsets rather than on a 17-inch monitor, or they're reading things in a Twitter feed that has a limitation on the space. I think it is important for us to give guidance, and we do reports, we do workshops, we do update the endorsement guides, things like that. So we do try to give, not just through enforcement. That's not the only way. And also when we do enforce, we often do a statement of some kind that explains what we're doing. Like I did in the design aware case, I had a statement explaining why am I supporting this and where I think the lines are on unfairness. So I think that's another tool we can use.
That actually makes me think of a question that should be somewhat near and dear to your heart. For example, the deception statement was a 3-2, right? The case that adopted it was 3-2. And as you just pointed out, there are other instances where the agency takes actions, but there are dissents, and it gives a minority commissioner an opportunity to say something. One could imagine that's actually, in some ways, a better sort of circumstance, a divided adoption of a rule because of the opportunity for that kind of comment than unanimity. But on the other hand, you have something as important as the deception statement that was not adopted by a unanimous commission, and I just wonder if it undermines it in any way, or gives you or others sort of pause about its correctness, I guess.
Well, I think one of the benefits of having a multi-member commission is that if we can reach unanimity, I think it has greater support and a little more shelf life, right? Yeah. I think that's one of the values. I mean, it's not necessarily the most efficient to have 5 people weighing in and deciding on everything, but I think it does create.
You learn a lot.
You do learn a lot. You learn a lot about yourself, I think, having to have this repeat play game. But I do think it's valuable to allow to have the. What happens that way is the differences get surfaced, right? When you've got a unanimous decision, you don't necessarily know what went into that. When you have these competing statements, much like through a court, the differences do get surfaced. And and I think it was interesting to me because someone came up to me at an event once and they said, "Oh, you're up at the commission. Are you up there writing a lot of? I hope you're up there writing a lot of dissents." And I said, "No, that's not my goal. My goal is not to have to write a lot of dissents. My goal is to push towards where we have the most agreement, because I think that makes the best outcome." And you don't know what happens behind the scenes, right? So when something comes out unanimously, you don't know what.
So what happens at the FTC stays at the FTC.
That's right, just like Vegas.
So can we talk about one of your dissents?
Sure.
That makes more interesting conversation.
Yeah.
Your dissent on COPPA. So I'm switching gears here, and so if you want to go back, that's fine. But I thought it was right on. Can you tell us about your thoughts generally on COPPA and your dissent specifically?
Sure. So the Children's Online Privacy Protection Act gives the FTC rulemaking authority to implement the statute. And in some areas, it gave the FTC more authority to define terms over time as technology changes. So, but in some areas, I think it didn't. So the statute defined what an operator is, and pretty clearly, and didn't give the FTC authority to change that. It also gave examples of what was personal information for children, but did give the FTC the authority to designate other similar types of information as personal information. So when the FTC revised the rule recently, it, I think, expanded the definition of operator to cover entities who weren't directly collecting information from children or using it themselves. So that is the grounds on which I dissented under the Chevron doctrine, basically saying Congress spoke directly to this issue and defined what an operator is in the statute, and the FTC wasn't given the latitude to change that, even if it sounds like a good idea, even if it, we think that it would be, a good update. Now we were given the authority to change the definition, to expand what we consider personal information based on, the parameters that Congress set out. So that's what was the basis of my dissent.
Oh, and
got to stick to the statute.
Yeah, and just for people who aren't familiar with COPPA, the definition of personal information expanded to include persistent identifiers, which is new. So that means not just name and address and photo, but also your device identifier on your iPhone or Android device. And so when you use an app, and that information is automatically transmitted to third parties like ad networks, analytics companies, when you use a social widget or plugin, the information that goes to those third parties can now be liable under COPPA if they have knowledge that they are collecting information from a child. So that's how it.
That's right.
That's how it expanded, just by way of a little more background.
That's right. And the statute had basically the idea was information that could be used to contact an individual.
Right.
So you mentioned earlier the role of economics. What would be the role of economics in the case of COPPA, for example, in measuring the impact on children's media? Do you think that sort of assessment was made in the fullest way that you'd like to have seen it made, or do you think that going forward that the Commission should, even in privacy or consumer protection cases, how should they weigh the effects of their regulation? I'll just maybe one specific example. In the COPPA rulemaking, there's a lengthy discussion in the regulatory impact statement, the part that nobody ever reads at the end of the order.
Speak for yourself.
That most people don't read. They're actually very fascinating.
If you were billing per the hour and I was willing to pay for it, you'd read it.
And that's exactly where I was going to go with this.
I was going to say, I bet you read it.
The regulatory impact statement was all about how many more hours is this going to cost an operator and what's the billing rate per hour. And it's not at all about what do we think the second order consequence of that is going to be. What does an operator being subject to COPPA at all mean for their ability to deliver a service? Are they going to just go out of business? Is this going to harm children's media? So how can the FTC get into more of those sorts of predictions about the impact of its rules or its enforcement actions on media and on innovation?
So those are all important issues, definitely important issues, and ones we need to think about. To the extent Congress decided what the parameters of COPPA, who it should reach, and what obligations it should impose on those people, that kind of ends the story. But to the extent we have some discretion, I always think it's important to look at that, and that's one of the questions that I think is important. As a policy question, is what we doing, or is what we are doing going to make consumers better off on the whole? So will there be more content available for children, or will this have a impact of it's too risky, so I'm not going to produce children's content? I think that's something we need to think about. But of course, once Congress decides, that's what Chevron is about, right? If Congress has decided it, that kind of ends the story for us.
Right.
Well, more generally on privacy, we've seen a lot of big changes recently in the private sector. Axiom, for example, has released a transparency dashboard to let users see what information Axiom has about them. And other companies like Google and Yahoo and Microsoft Facebook have all done similar things. What do you think about the state of privacy? Is the marketplace working overall, or what's the FTC's role in helping to serve consumers here?
So I just got back from Poland last night because I was at the conference of data protection authorities, right? That's what DPA stands for. And I gave a talk actually on consumer and business education because one of the things, I talk about our many tools, and I hadn't talked about education. And that is one of the most important things that the FTC does, one of the most cost-effective things that we do, is consumer education and education to businesses, for consumers to protect themselves and for businesses how to adhere to the law. So in my 26-slide deck, I did include the Axiom about the data site because I think there are companies that are providing more information to consumers. I think there are companies that are starting to compete with each other on the basis of privacy. I think that's very good, and that's one of the things where, as I said, take a look: is the market solving some of these problems? Axiom does think I'm a Democrat, which surprised me when I looked about my own profile. So I guess
so
they don't have everything right.
Listen, if all the data they have is wrong,
I know.
Nothing to worry about.
But anyway, no, I think that's good, and I think there does seem to be a movement towards companies giving more tools to consumers more information. I think that's all to the good.
So before we move on to antitrust, before taking questions, what's the FTC's role in general? I mean, how would, given what you were saying about its mission, what do you think its priorities should be in the area of privacy and data security?
So privacy and data security, particularly in privacy, my view is that our job is to make sure consumers have the information they need to make the decision for themselves. So whether they get it from the company or they get it from us, or there's a host of ways they can get it. And then once the consumer has made that choice, that choice be respected. I don't see in my role as saying, consumers, you're making a choice that I don't like, so I'm going to preempt that choice. On the data security part, I think it's, that is under our unfairness authority. I think it's important that companies do take reasonable steps to safeguard the data that they have. In a way, it's a little bit different than some areas because having data be, as long as the steps are reasonable and companies can, one of the things I say is like, look, we're not expecting that you can withstand, Tom Cruise hanging from a rope in the CIA kind of infiltration of your data. But a lot of this is like basic precautions aren't being taken because there's not a great benefit to competition, I think, of data being stolen and sent off. Right? It's not an exchange for value, which you might see in a more competitive market. So the FTC should do enforcement, but should also be giving guidance and giving consumers basically helping make sure that consumers' choices are well informed and then respected.
Do you think a data security workshop would be helpful to explore how companies should understand their evolving duty to provide reasonable data security?
Yeah, I think that actually could be helpful. The FTC's workshop function has been very helpful over the years. Speaking as a person who's run a lot of workshops, which are an amazing amount of work. So.
And just on the point about what you were just saying about unfairness, so obviously there's no benefit from having bad data security, but there is a cost to providing data security.
Right.
So if unfairness is about cost-benefit analysis, not to ask what the right answer is, but over time, how does the Commission make clear how companies should figure out that weighing? How do we all know where the goalpost is?
So the companies need to take reasonable precautions, and that will change over time as the technology changes, and as depending on how sensitive their data is. So some of the cases we brought, or many of the cases we brought, are failures to take very basic steps. Right? Don't have your password be password. We often talk about technology, but some of these things are people taking paper records, pharmacy records and throwing them in the dumpster, paper copies of mortgage applications that have your social security number, your address, your employer and everything, and throwing it unshredded into a dumpster. We also have cases where there's no firewall. There's some very basic things. So.
Actually, let me ask a question about, switch gears a little bit, about process. So you talk about those cases, the basic cases that were brought. Well, let's say, and I think this will be interesting to hear your viewpoint, given your experience working before the FTC and now, of course, as a commissioner. So if you you're a company, you get a CID, civil investigative demand, and they're asking questions, and staff goes forward with their investigation, and ultimately they make a recommendation to the commissioners. Do you have any advice for companies if they've cooperated with staff, they're working with staff on the response to the CID, they think they didn't do anything wrong, they don't want to enter into a consent decree for obvious reasons? Do you have any advice for them in approaching commissioners? At what point should that happen? Any recommendations for when they do approach commissioners? So pretty broad question, but from that standpoint.
Sure. So primarily they should work with staff, and then once it gets up from staff's recommendation to the Bureau of Consumer Protection Leadership, and they've kind of, reached, best and final offers or whatever at that point, that's the time that they should come in and talk to the commissioners. Now, our doors are open. We are willing to meet with them, but we have to typically, I would meet once the positions have sort of come to a settling. Not that they have to settle, but each side, there's no further negotiation that's going on.
So once the staff then, are you saying once the staff then makes a recommendation for an enforcement action, and then that at that time,
Right.
you would, okay.
Yes. Yeah. Right. Because the staff hasn't recommended an enforcement
There's
action.
nothing to talk
There's
about.
nothing. Right.
So I promised Jeff we'd get into competition, antitrust, and
Yes.
patents before turning to questions.
Okay.
If you have a question, or just discuss.
Well, no. All right. So I'll ask one question, but we should probably get into questions. So, you mentioned the Google case, and I want to ask.
I mentioned two Google cases.
Well, right. So
the search
so
and
there's the search case
the
is what
SEP
I'm going
case, okay.
to ask about. Although I'm of course interested in both, but one of the things that came up in the discussion around that case, or at least that I said, maybe I was talking to myself, was sort of this problem you mentioned just a little bit ago about keeping up with technology and,
Yes.
and enforcement lagging behind a little bit, and that's inevitably the case. So I suppose I would phrase the broad question this way. What do you think, if anything, the FTC can do to minimize that problem? Right, it's essentially an error cost problem. So we could suggest that in part this is overcoming as much of the uncertainty as possible about the technology being regulated and the consequences, the actual existence or possibility of consumer harm. It's a tough question, and you addressed a little bit in your talk. Things that the FTC has done, like having a technologist, for example. But I suspect that there's more, and maybe you have some thoughts about how you deal with this over the next 100 years when the problem is only going to get worse, if anything.
So one of the things that I try to do, and I do this both on the antitrust and the consumer protection side, is to really go out and engage with people, not just stay back in my office. Because I learn so much when I go and I meet with companies. I go out to Silicon Valley a couple times a year. I try to keep up with the technology. I'm actually doing a Reddit. Ask me anything on privacy. And yes, I am.
When is that?
So the date might shift a little bit because of the possible government shutdown. So it'll either be next week or the week after.
I hope no one takes over your account while you're trying to do it.
I hope not. I hope not. We'll see. But I'm going to be Skyping to participate in a conference in Europe. So I have a Twitter account now. So I think it's important for us to keep up.
But are you on Vibe?
No, what's Vibe? All right, you got to tell me afterwards.
They're behind. They're always behind.
Hey, I'm admitting I will always be behind, right?
6
Okay.
second segments.
Okay. Oh, Vine.
Vine.
Yeah, excuse me, Vine.
See, I knew what Vine was, Baron.
No, Vibe is a new thing.
Good.
You just made it up.
Good
I
catch.
did.
But anyway, no, I think it's really important for us to continue to engage. So as we go out and we meet with companies, I like to hear what they have in the pipeline, what they're doing. I'll be out next week in Seattle. I was in Silicon Valley in the spring. I was there last fall. And, you can't always tell what's going to, you kind of take in a lot of information. And you can't always tell what's going to be, the most useful part. But it's really important, I think, as a commissioner to try to keep up and not just kind of sit back in my office and say, what comes across my desk. I really have to reach out and gather that information. So I try to do that.
Well, I think the general rule is if it's not at the top of Reddit, it's probably not important. So anyway, we'll take some questions from the audience. Ben Sperry from ICLE is going to run the mic. If anybody would like to ask a question, just please identify yourself and put your question in the form of a question.
And if not, we have more.
So.
Jerry.
Hi, I'm Jerry Searso from DMA. Just a question. I think today the Commission announced it's going to do some 6B action on looking at patent trolls and so forth. And it's been very important, becoming a larger and larger problem for members of my association with relatively vague software type patents. And anything you can add or say to that on your action today?
Sure, absolutely.
And what is 6B for
okay, so
Reddit?
6B is a authority that the FTC has to get confidential information for the purpose of studies. So we announced today that we are doing a study. Okay, it's not an investigation, a study involving patent assertion entities and other non-practicing entities, how they, what patents they have, how they assert them, what their future plans are, with the idea of, there's a lot of debate going on about patent assertion entities. Some people are concerned that they are generating a lot of litigation, that it's imposing costs. Others say, well, they play an important role of allowing small inventors or small businesses or universities to assert their patents against bigger players. So what I mentioned using all of our tools, and our research tool is a really, really important one that the FTC has. So this study, it's out for public comment. I encourage everyone to submit comments if you think we've identified the right people and the right questions. It will be published in the Federal Register, and the comment period will probably close around the middle of December. But it's a really good use of our, multi tools.
It's actually it's interesting because like your dissents in Bosch and Google pointed out, there's this potential for the FTC to be stepping on other agencies and, for that matter, courts' toes, particularly in the patent area. And that strikes me as exactly the kind of thing that, if done right, is of a piece with the competition advocacy and
right.
That sort of approach. You have the opportunity to collect and potentially provide a lot of very useful information for those other entities that are primarily tasked with, and the USPTO, of course, with defining the scope and permissible enforcement of patents.
Right.
But it doesn't mean that it necessarily is leading to the FTC jumping into this game because they've collected data on it.
That's right. That's absolutely right. We don't have enough data to know, is this a competition problem? Is it a patent problem? I mean, there's a tendency that if all you have is a hammer, everything looks like a nail. If all you have is an antitrust authority, everything looks like an antitrust case. This is a way to just bring more information into the debate, to bring more light to it. Whatever the problem is, if there's a problem, and then whatever it is, having more data, I think, will help make things much clearer.
Well, given that the FTC in the past has been creative with animated characters like Dewey the Privacy Turtle,
I remember Dewey the Turtle.
I might suggest that before you do your Reddit AMA, if you could have a clever graphic for suggesting that the FTC is going troll hunting, even if that's not an accurate characterization, it would be a great way to excite the Reddit.
Word is patent assertion entity,
Yeah.
and not practicing entity.
Patent assertion.
What you just suggested would be horribly problematic for a lot of people.
Yeah, but it would get Reddit excited. Now,
well, that's all that matters.
Now, is Dewey the Privacy Turtle going to get a remake, an uplift?
I don't know. Dewey's been in retirement for a while, so we'll see if he comes out of his shell again. So.
Any other questions about FTC animated characters? Or
I knew you were going to say troll. I knew you were going to get that in here.
Dewey, I'm just saying, this could be Dewey's opportunity to come back.
To resurface.
Neil?
Neil Chilson from Wilkinson Barker. Maureen, you were talking a lot about the FTC's one of the tools that it has is to reach out to other government agencies and to coordinate. And you were also talking about like the possibility of stepping on jurisdictional toes. The Consumer Financial Protection Bureau, new, still not clear what's going on there, and I'm wondering how the FTC is going to interact with that agency. Sorry, I misstated the name of the new
CFPB.
CFPB, but the
Consumer
new
Financial
agency
Protection
that's
Bureau.
there. Yes. How is the FTC's role shifting in financial protection for consumers?
And you maintain privacy enforcement.
We do. So yes. So under the Wall Street Reform Act, the CFPB got a rulemaking authority in the financial protection area, and the FTC did maintain its enforcement authority. CFPB has enforcement authority as well. So we have I think a memorandum of understanding with them, and are trying to coordinate to make sure we're not duplicating efforts. But it's an ongoing thing. So.
Well, you've had that sort of relationship with the Department of Justice and antitrust law, in a
yes,
sense.
we do. That's right. We can both enforce. we have sort of an informal agreement on how we clear matters based on expertise between us and DOJ. And then we, because of our status, don't do criminal and we don't do common carrier. We don't do banks, so those all go to DOJ.
So let me just ask you about the common carrier exemption. So you mentioned that one of the things you'd like to see Congress change, ideally, would be allowing the FTC to regulate common carriers.
Yes, to enforce the
enforce.
consumer protection.
Right. And I would very much agree with that. I think you're quite right that it's an outdated exemption. But there are also areas where, even if that's not changed, court decisions may end up putting certain industries like broadband. If the Federal Communications Commission, of course, is facing a court challenge right now to its open internet rules,
Right.
and the court may very clearly hold that the FCC has unlawfully tried to regulate broadband providers as common carriers, and that they are not, at least until the FCC tries to reclassify them. So you've written about this in the past, about
Yes.
the FTC's authority over broadband. What role does the FTC have today over broadband? And if there is a net neutrality complaint, and let's say that the DC Circuit does strike down the net neutrality rules, is the FTC the cop on the beat, and is it up to the job?
So I think the FTC is up to the job. In another report that I did, the competition policy, what was the name of that report, Greg? Broadband Connectivity Competition Policy.
That's 2007?
2007, June 2007. We did talk about this, and I do think that the FTC has, under our antitrust and consumer protection authority, the tools to address these issues. Broadband, so our common carrier authority is not determined by the FCC's definition of what's a common carrier is, but it certainly makes it easier if the FCC hasn't designated something a common carrier. So in the Brand X decision, its decision that broadband was not a common carrier was upheld by the Supreme Court. So we have authority over broadband and have taken actions in that area. So I think should the FCC's open internet order get struck down, certainly something the FTC or the DOJ could address through traditional antitrust authority. So it would be some sort of Section 2 case, but also consumer protection. So if a consumer has been promised you're going to get certain speeds, or you're going to get internet access that doesn't have any throttling or what have you, that's a pretty straight up consumer protection authority, consumer protection case. So that's another tool we could bring to bear.
Well, this might be a good place to wrap up. So there is some of that self-regulation today. There's a lot of talk in Washington about multi-stakeholder processes. The White House, of course, is apparently about to drop a bill that would give the FTC authority to certify self-regulatory programs, but you already enforce self-regulatory programs today. So do you want to say anything just across the board about if broadband companies make the kind of voluntary commitments that Verizon and Google did, or if the online advertising industry makes certain commitments, the FTC is responsible for enforcing all of those without having to make an antitrust case. So do you see that as being perhaps the linchpin of unleashing new paradigms of regulation in the future, with the FTC as an ultimate backstop?
So self-regulation can be a very useful supplement to the FTC's, enforcement authority. Generally the consumer protection area, really. And so we do enforce if there's a self-regulatory program and someone has promised they will adhere to it, and then they don't adhere to it, that's where our authority comes in. It's really deception-based authority. But no, I think, if there is self-regulation that is, robust, that it has some enforcement backup, that it has teeth to it, I think that's something the FTC has been supportive of in a wide variety of areas, including, advertising, I'm trying to think of other self-regulatory areas. I'm looking at Pablo.
Privacy and interoperability.
Yeah, yes, right.
Interoperability.
Yeah.
So just to wrap up here, what would be your top 3 priorities for this 100th year of the Federal Trade Commission?
So I think, look back to my notes because I did lay them out here. So
Updating Dewey, the privacy
no,
tool.
not updating Dewey. More clearly tying our enforcement goals to our mission. More clearly explaining why this is good for consumers and consumer welfare. Staying focused on our core competency, which is antitrust and consumer protection issues. I think that's really vital. And if we are going to use unfair methods of competition authority, which I don't advocate that we use, but if we are to use it, that we clearly state and give a clear statement of what that means before we use it. And as always, just try to keep up. Try to keep up with what's happening.
So would you add anything else for the FTC at 200 event that we're going to be hosting?
Oh, yeah, I will be there. I will be hosting it.
Anything you want to say?
Having spent yet another century at the FTC.
Right. Yeah.
Anything else you want to say to future commissioners?
It's the best job in the world.
All right.
I would say I envy them because it's a fantastic job.
Well, Commissioner Ohlhausen, thank you so much for coming. Thank you to Holland and Knight for hosting us, Chris. Thank you to the International Center for Law and Economics for co-sponsoring this event. Thank you to all of you for coming to this Tech Freedom event, and stay tuned for more events on all the topics we've discussed today and many others across the field of tech policy. And we'll send out a save the date for the FTC at 200, which I'm sure you'll
September 26th.
14. We'll be there. We'll be on Twitter, and who knows what else.
By then, Vibe will actually be.
I'm actually launching Vibe next week. I slipped on that. It's a lot like Vine, but more fun.
Okay.
So thank you all for coming.
Thank you.